appeal in the matter of Asertis Limited and Heathcote.
Yes, Ms. Bedford.
Good morning, my lord. May it please the court, myself and Miss Carter appeared this morning on behalf of the appellants. My learned friend, Mr. Vise, appears on behalf of the respondent.
Yes.
As a short matter of housekeeping, the way that the appellant intends to proceed today in the event it pleases the court is that myself is going to have major carriage of this appeal, but if there are any issues arising out of the granular aspects of this claim, the intention is for Ms. Carter to speak and address the court on those issues, also bearing in mind the recent guidance on juniors
Yes.
having more of an active role.
Yes.
My lord, I'm grateful. The appeal before you this morning arises by way of the appellant's notice dated the 20th December 2022.
Yeah, we've read the appellant's notice and the skeleton arguments and the judge's two judgments.
Thank you, my lord. Grateful. In that case, perhaps maybe I can just cut straight to the issue, in particular taking account of the directions of the court yesterday to take into account the authority which came out from the Court of Appeal a matter of 7 days ago, I think, which is the case of Price and Superwall. I say that it is important, and it's important for this reason. It goes to the central issue of this appeal, which operates in respect of both the first and second defendant in the rewards claim. Unless my lordship wishes me to review and go over the facts and circumstances of that reward claim, which was a preference claim, which was the three aspects of it: an unauthorised remuneration from director's loan account, transaction at undervalue defrauding creditors under section 423 of the Insolvency Act, and breach of creditor's duty. The conclusion to that claim was that the claim was dismissed by His Honour Judge Davies during the substantive trial, but nonetheless he was persuaded to enter judgment for the gold payment for the sum of £7,800. The appellant says that that was an insignificant sum, and in any event the matters arose to an insignificant feature of the claim in any event. And then the second payment claim as constituted, which was a preference claim under section 239 of the Insolvency Act, amounting to a sum of £65,000 only, that was constituted against the first and second defendants, and that was awarded to the claimants in full at trial following the 3-day trial. The central issues in this claim, this appeal, my lords, is this: whether a cost order can be made outside the confines of a claim, which is the matter that Superwall goes to directly, and the identification of a successful party in a claim where at its height it involves de minimis damages, and thirdly, the weight and effect that ought to be given to displacement factors, including the issue of a mediation being offered and not accepted. There's an interesting issue perhaps in respect of the £85,000 offer which was made 10 days before the trial, which was not rejected. That will be addressed, and amongst others raised within the Respondents' notice, which includes whether it's appropriate to make an analogous third-party cost order against the second defendant. The defendants, in particular the second defendant, say that the third-party cost order only arises in circumstances where this court is against the first defendant's position that it was the successful party in the rewards claim. The reason being is that once the successful party has been identified, it falls away that the claimant is in fact entitled to costs, such that it needs to decide where the paymaster ultimately falls. So with your permission, Your Lordship, I'll turn to Price and Superwall and Flitcraft, which of course was a decision of this court, which is to be found under neutral citation number 1 CIB 136.
Yeah.
You'll find that at page 3 of the supplemental bundle.
Yes. And it's Lord Justice Nugent's judgment.
It is. There were two aspects to the judgment, my lordship, you're correct. The first engaged by Christopher Floyd. And there, if I just rest perhaps here for one moment and take you through page 3 of that bundle, which sets out the factual matrix which engaged upon Superwall. You'll see at paragraph 2 that the factual matrix was such that the claimant seemingly sued all defendants for infringements of 2 patents, infringement of copyrights in photos, and for passing off. So just pausing there, what one sees immediately is that there's connectivity between all claimants and all defendants within Superwall. I say that is a distinguishing feature, of course, from our claim, the appeal before you, such that the position in Superwall is more stark in the appeal which is before you because of that lack of connectivity. The claims which were brought by Mr. Price were all dismissed at trial. The claim which was brought by Superwall succeeded in part, subject to the joinder of the official solicitor, which was the issue before Mr. Justice Floyd. Subsequently, the ultimate outcome was that Superwall was entitled to partial relief against the defendants. And one can see this from paragraphs 2 to 3. If I can then please turn your lordships to the judgment of Lord Justice Nugee, which you'll find at paragraph 60 onwards of the decision, which is at page 16 of your bundle.
Yeah.
What you'll see here is the approach which the judge took at first instance. And there is a matrix, in short, that he followed. And one can see this set out at paragraph 60 onwards. And it was a claims-focused approach which was taken in order to ascertain the position and identify the successful party given the cross-pollination of issues within the claim. The judge first started the position by apportioning the costs between all 3 claims which were brought. One can see that from subsection I, Roman numeral 1. That was not challenged. Having done so, the judge then turned his mind to who, in fact, was the successful party within those claims. And importantly, he noted that he needed to deal with the claims separately. He then, having done so, apportioned the claims overall in respect of the element which succeeded in respect of the patent claim. He apportioned 60% of the claim to Mr. Price, which was unsuccessful, and 40% to Superwall's claim, which was successful. And having done so, what he did was he then utilised that matrix as a confined and defined path through which he could analyse who was the successful party and who was the unsuccessful party for the purpose of 44.2.
I think, if I may say so, that we just need to look briefly at what Sir Christopher said about the cost judgment at paragraphs 24 to 26. Because he points out in paragraph 24 that at the costs hearing, both parties invited the judge to look at the case in the round.
Yes.
And then the judge declined to do that and said there were 2 separate claims. And at 27, there were elements common, but nonetheless he dealt with the cost of the claims separately.
Yes, absolutely, my lord. And what he did thereafter was follow the proper the matrix which is set out at paragraph 60, because what he concluded was, or what the judge considered was a 50-50 split on all matters, was not correct. And the reason for that, in my submission, is because of the multiplicity of claims which proceeded, not least, of course, because there were 3 claims brought by the claimants against the defendants. And so on that simple mathematical basis, in my submission, it didn't necessarily follow that it was a straight 50-50 split, particularly given the loss of the claims or the failure of the claims on behalf of Mr. Price on all 3 bases, the success of Superwall, but the narrow element of that success only on 1 partial issue. So when one looked at it on that basis, in my submission, it was difficult to ascertain that the claims themselves did in fact have a 50-50 split, which ought to have been the premise of the costs order. And as a consequence of that, and because of those interconnected and cross-pollinated differences, what the court did was approach the basis upon, or approach the costs order through the lens of who actually is the successful party. And of course that's procedurally correct in my submission, because that is the starting point under CPR 44.2a. One has to look through the lens of who is the successful party as the starting point. If one looks through the lens of an apportionment as to where the costs are borne out, well, the difficulty one gets to is that one doesn't immediately identify who the successful party is. So what one can see through going through the matrix of paragraph 60 is that the judge had to separate out these claims in order to ascertain as a starting point who the successful party was. And in my submission, that is the premise upon thereafter which Lord Justice Newby continued on to assess whether that was the correct approach or not. So returning back to paragraph 60 in that matrix, one sees that having ascertained and identified who was in fact the successful party through the lens of each of those claims, the judge then thereafter deals with the displacement factors from Roman numeral 6 onwards.
Yeah.
By attributing a reduction for elements which had not succeeded. And one can see that he's done that by way of a percentage deduction. That in and of itself, of course, as a percentage deduction contingent upon a displacement factor in my submission, it is an entirely correct approach, and indeed it's the one which was ultimately upheld. It's also relevant, my lord, that you'll see at paragraph 61 that both Mr. Price and Superwall were jointly represented, and you will see that this was not a factor which had any significant weight in how the judge ultimately approached the correct question as to the formulation of how one ascertains success within any individual claim. Which then leads on to paragraph 63, and you'll see there that that confines and defines the appeal which was taken. And in my submission, what one immediately sees is that it is the converse to the situation which is before you, that having addressed his mind to the confines of the claim in order to ascertain the successful party, the appellant in Superwall appealed on the grounds that that was the incorrect basis. And in particular, if one goes over the page to 18, one sees on the continuation of paragraph 63 that one of the basis was, or the principal basis, was that the claim had been brought jointly and that the claimants had in fact been the successors over all. When one takes them jointly. We then get to the crux of the decision of paragraph 64, which is that that decision or that submission was not accepted. And Lord Justice Newby rejected those submissions on the following grounds. But firstly, the claimant's position was impermissible as it treated both claims as if they were a single claim which had been successful overall. They had not been.
Yeah.
They were two separate and distinct claims. And in my submission, my lord, that's exactly the issue which is before you today. We had two separate, distinct actions which were brought firstly against the first defendant in respect of the rewards claim, and secondly against the first and second defendant together in respect of the payments claim. And what one sees from paragraph 4 of the judgment of is Honour Judge Davies, the learned judge, is that he treated both claims in totality together.
Well, was he asked to differentiate between the two?
If I can turn you in that, as I understand it, is going to be the claimant's main position this morning. And in that respect, what's helpful is the skeleton argument of both parties, which sets out the principles and the basis upon which the judge was invited to address the claim. Before I get to the defendant's skeleton argument, perhaps I can take you to the claimant's.
Yep.
I do so because it's illuminating. And you'll find that at page 203 of the core bundle.
Two 8-3.
Oh, sorry, forgive me, Melody. 203.
2-0.
Yes.
Yeah.
Thank you. The first deals with issues of interest and judgment being entered. I don't need to trouble you with that. But if I can take you to page 206 to cut across where we get to the costs issues. What one sees is the treatment from the claimant as to these issues. And the court or the judge was invited to take into account what the final score was, inclusive of all relief. and that's at paragraph 19. In my submission, the final score, of course, was only properly referable to the totality of the amount which had been ordered by the judge, taking into account the rewards claim and the preference claim, which was a sum of £85,070.60. But by inviting the court to start from the position of the final score in totality, rather than ascertaining the amount in respect of the rewards claim, which at its height is £7,800 plus interest, and the payments claim, which is £65,000 plus interest, it was the claimant that was asking the court to start from the incorrect position. And one sees that continues on through paragraph 22. The claimant is the winner, the claimant has secured a substantial judgment in its favour, and consequently the conclusion the claimant invited the court to take was that the starting point was that the claimant was entitled to its costs. Then over the page at paragraph 26, the court is respectfully asked to bear in mind the following. And what the claimant thereafter did was it engaged immediately on analysis from the totality again of the claimant's, in their view, success, and that the total amount was not a trifling consideration. And importantly, the court was invited to have significant regard to Fox and Foundation Piling Limited, a decision of Lord Justice Jackson in this court from 2011, which can be found in neutral citation CIV 790. And that turns out, in my submission, to be utterly critical, ultimately, to the judge's reasoning. I will take you momentarily through the judgment itself, but just to pause and to continue on, pause that issue and continue on in respect of the claimant's submissions. It was the claimant's submissions that the court accepted and followed.
Yeah.
One then goes over the page again to subsection B. The defendant's best argument is to rely on paragraph 49 of Fox, and you'll see that the notion and the language that is used is the rewards issue, not the delineation of the rewards claim. And it was the claimant, in my submission, that set that hare running.
Yeah, but was it challenged?
If one goes over the page, my lord, to 212, which is where the skeleton argument starts of the defendant, there is a submission at paragraph 2, and you'll see it says this: for the reasons stated in its letter, the claimant's position that it succeeded in both claims. And then it says this skeleton sets out why C's position is misconceived and why it's appropriate for the court to order the claimant to pay all or most of the claimant's defendant's costs on the standard basis. But then what one sees from paragraph 3 onwards is an analysis of the claims through the different lenses, of the successful party, through the different lenses of these claims. In particular, at paragraph 4, you'll see that it set out the differences between the success on the rewards claim and the success which is against D1 only, and the success from the first defendant and the second defendant on the payment claim. There is then...
The conclusion which you Scarter drew from that was that because the payments claim was only a small part of the total, you should be regarded as the winner overall. I'm not sure I see in this skeleton a submission that the two claims should be treated separately for costs purposes. And if it is there, it would be helpful to be shown it.
Yes, my lord. The language I accept is perhaps not as specifically put as it is within this appeal before you today. But the approach that was taken, which is the difference and the material difference in my submission, the approach that was taken was the invitation to analyse the successful party by reference to the rewards claim and the payment claim. And once that analysis had been taken in respect of both those two claims, what Miss Carter did in reality and practically was to take a step back. And having analysed the successful party for the purposes of the rewards claim, having analysed the successful party for the purposes of the payment claim, undertake a position overall. And actually that's the position, if one looks at paragraph 60, that Lord Justice Newgee, in Superwall, that Lord Justice Newgee approved, ascertaining who was the successful party And then in certain circumstances, which is at paragraph 65, one can step back and say, well, what is the reality of the position in this claim, and is this such that I should follow that as opposed to following the distinct pattern of claim, success, claim, success?
So, if you're right, what order are you asking us to make?
That the claimant pays the first defendant's costs of the rewards claim, and it's accepted that when one analyses the payments claim, that the claimant has succeeded on that, and that the claimant gets their costs as paid by the first defendant and the second defendant. In reality, my lord, the mischief here is on the rewards claim. It's on that first claim. Because at the moment, what happened was, the result of the order is that it's a manifestly unjust order, because despite having enjoyed substantial success, that at the height of it, it's a 1.5% recovery for the claimant in totality, or on the rewards claim, which for the reasons that I'm going to come on to, I say is de minimis and ought to be treated as such. But nonetheless, the judge has fixed the first defendant with the costs of the claimant up to the tune of 75%. And when one looks at it through that lens, in my submission, my lord, that it is a manifestly unfair order, having regard to the principles as to who is the successful party and the degree of that success. And secondly, that the second defendant has been fixed with the burden of this cost order equally in circumstances where they were never a party to this claim in any event. There is, of course, a respondent's notice trying to deal with the notion that this court ought to make a third-party cost order against the second defendant, but for the reasons that I'll come on to, that is utterly doomed to failure in my submission, simply because it doesn't satisfy the test, nonetheless, on a third-party costs order. So continuing on through Ms. Carter's skeleton, that is the basis of the claim, the defendant's position, and you can see this completely in my submission delineated out by paragraph 16 of her skeleton, which is at page 216. The successful party. Whichever way one looks at it, the claimant's position is that it has succeeded in both claims is misconceived. Claimants succeeded on the payment claim only, and the defendant succeeded in defending the rewards claim. So what she's done there is that she's addressed and identified the correct starting point, which is through the lens of each of these claims, who was the successful party.
But the punchline for that paragraph is paragraph 18, saying treat us as the winner overall.
Absolutely, my lord, but if what she's done first, though, is ascertained who is the successful party in either claim, that's two difficulties with the claimant's position on that. That's not what the claimant did in the skeleton argument put forward by Mr. Cochrane. He combined both of the two claims together in order to look back at that and ascertain the successful party, having regard to both of them in a conjoined and aggravated fashion. And that's not what Ms. Carter did. She properly identified the successful party through the lens of each claim. And if I may, perhaps the distinction is this. It's that it's which question comes first. And this is not a chicken and egg question. This is a proper process that follows a specific pattern. One has to, in my submission, initially identify the successful party on each claim. And having done so, one can then take a step back in certain defined circumstances, which are identified at paragraph 65 of Superwall, to say in these defined circumstances, and that it was considered an exception. So these exceptional circumstances, one can say, is there to be an adjustment overall, having regard to who overall succeeded on the claim. But what one can't do is start from the converse position and look at it through the lens of the other direction. So look at it backwards. One can't start from the position of who has succeeded overall without having sufficient regard to who had success on the first claim or on one claim and who had success on the second claim. And when put properly into context, that is the position that the claimant adopted, which is different with the position that Ms. Carter adopted. And for those reasons, in my submission, whilst there may be a difference of language on these appeals, the thrust is still the same purpose, that one needs to look and analyse the position and what the judge did through the lens of the starting point of who is the successful party on each claim. Thank you, my lord. If I may go back to paragraph 65 and 64 of Superwall.
Yes.
What you'll see here is paragraph 64. This is the starting point. This reflects the submissions that precede that I've just made, and equally also reflected my submission, the position which was taken by Ms Carter in her skeleton. I do not accept this submission. There were two separate and distinct claims, and they are separate causes of action vested in separate claimants, and if successful would have resulted in separate judgments, which of course is what one had here. And then importantly, paragraph 65. This is not just a technical point. In many claims brought by more than one claimant, the claimants are associated parties. Just pausing there for a moment to address the issue of associated parties in this claim. There was, of course, only one claimant, so there wasn't a severance in terms of the claims, there wasn't a severance in terms of claimants here, as one saw from the multiplicity of parties in Superwall. We had one claimant and one defendant. But in the event that one can analyse the position through the view of the defendants, this, of course, was brought against the first defendant in his personal capacity. It was the second claimant was his prior, or his company that he was the sole director and shareholder of before, but of course that had gone into compulsory voluntary liquidation, voluntary creditors liquidation, forgive me. And as a consequence of that, in my submission, what one sees is that the benefits and the rights and remedies are all vested in the liquidator to recover the funds on behalf of creditors. But what one has quite curiously in this claim, of course, is that there's been an assignment between the liquidator to this claimant in respect of those benefits. So if one's looking at the financial benefits to be drawn from defending this claim and where the benefit lie, in my submission there is no alignment between the first defendant and the second defendant in the terms which were spoken of by reference to paragraph 65 of Lord Justice Newby's decision, because what one does not have is commercially aligned interests. And in my submission, that is the exceptionality which is carved out by his lordship within Superwall. That if in circumstances when one is undertaking that step-back test, having ascertained who is the successful party through the lens of each claim, if there is aligned benefits and aligned economic benefits between the two parties, that one can, in narrow circumstances and narrow factual circumstances, ascertain that the reality was that they were all going to be getting the same benefits at the end of the day. That's not this case. And for those reasons, in my submission, my lord, the position adopted by the claimant that this is one of those exceptional cases, in my submission falls foul because it simply cannot satisfy that joint beneficial interest test which is carved out by paragraph 65. So in consequence, in my submission, this the authority of Superwall is directly on point and is instructive in respect of this appeal today. If in that respect, if I may turn you to the judge's approach itself within the core bundle, you'll find it at page 56. Sorry, forgive me, 54 is where we start. Forgive me. Paragraph 2, I say, again, is instructive. What one sees is that the majority, at paragraph 2, one sees that the majority of the pleaded case, as far as to say, dealt with the response the claimant made in anticipation of the justification advanced by the defendant for that payment, which is to say that it was remuneration paid by contribution through the EBIT scheme. What one then goes over to paragraph 18, which is at page 56, is where we see how the judge treated the question of costs. And in particular, what is illuminating, my lords, is that you will see the process that he followed. And in my submission, the process that he followed aligned with the claimant's approach within the skeleton argument as opposed to the defendant's approach.
Yes, you see that at 21.
Absolutely, my lord, yes, thank you. So what one will see is that there is a singular focus upon the outcome overall. Who has won? It is, as I said, in my clear in my judgment on the authorities that it is the claimant. So there is a
Well, in fairness to the judge, it looks from paragraph 19 as though the sequence of questions which he asked is what he was asked to do by your side.
He was asked, well, forgive me, my lord, it may be a nuanced issue and I may be dancing on the head of a pin, but I would suggest not. What he's done is he's approached who has succeeded by that singular focus. The focus upon who had succeeded in the claim through the process of analysis on Miss Carter's skeleton was to identify who had succeeded on the payment claim and who had succeeded on the reward claim. What one does not see overall in paragraph 21 is a focus upon who'd succeeded in one and who'd succeeded in the other. What one sees is a focus upon the overall outcome. And one can quite clearly see that in my submission from the considerable weight which the court gives to the claimant successfully sued and obtained $65,000 plus interest in relation to the payment, the preference or misfeasance claim, which I referred to as the payment claim. And then what he does is he contextualises that in context of the rewards claim, even in the context of. So as a consequence of that, in my submission, that is the clear focus upon who succeeded overall without proper consideration of who succeeded firstly on the rewards claim, who succeeded secondly on the payments claim, and then standing back to ascertain whether there was in fact joint financial gain to be gained by both defendants across the payments claim and the rewards claim, as one sees through the exceptionality test within paragraph 65 of Superwall. So what one sees in my submission, my lord, is an inversion of the correct process. And this follows the invitation at the claimant's counsel's request. And as a consequence of that, what one sees is that actually there's only one set of judicial scales that are utilised in ascertaining where the costs ought to properly fall. And in my submission, there ought to have been a proper consideration of each claim, which would have resulted in two sets of judicial scales in order to ascertain the correct starting point before, if there was, on the facts of this case, an ability to apply the exceptional rule. And in my submission, for those reasons given, this is not such a case. And one nonetheless sees that from the final paragraph. Nonetheless, its complete success in relation to the payment claim is real, substantial, and not an illusionary recovery. One then puts that within the context of paragraph 22. It's apparent from my substantive judgment the claimant won on two of the claims which had advanced and lost on the other, the rewards claim.
What are the two claims on which the claimant won?
And from what I understand, I think he's referring to the success against the first defendant and the second defendant upon the payment claim. And
Right.
then that's the only understanding that I can obtain, because there weren't three claims, there were only two, unless he's delineating out the payment claim such that it was one claim against the first defendant and one claim against the second defendant. But what I say that in fact shows and directs towards is that the judge was taking these as issues in reality, irrespective of the language that was used, and he was weighing all of them up together, again taking them in a single set of judicial scales, which I say is impermissible. And that is further explained by where he says, it is clear that what I'm looking at are the three claims, not the various legal ways in which the claims were put at trial. He then goes on at paragraph 23. It is in my judgment important to say straight away, I'm satisfied that it can't be said that the claimant's pursuit of the rewards claim was in any way unreasonable, and nor was the rewards claim in any way exaggerated. In other words, this is not a case where the conduct of the claimant in taking the rewards claim to trial can or should be criticised. So what he does there is treats the reward claim in my submission as a displacement factor. again supporting the notion that what the judge did was weigh the entirety of the proceedings in the judicial scales. The rewards claim and the success on the rewards claim, in my submission, is not a displacement factor under 44.2 subsection 4. It is a primary driver as to the successful party under the primary question of who, under 44.2.2a. And in my submission, the way that the court does this is by following the authority of Fox and Foundation Piling, which was the decision of Lord Justice Jackson from 2011, as had been quoted within the skeleton argument of Mr. Cochrane, which was set out at page 207 of the bundle, the core bundle, and in particular the claimant skeleton argument. This also reflects across to read back to the reference on "it's clear in my judgment on the authorities," which is again at paragraph 22. So what one sees is that the judge was following, in my submission, an incorrect and, or perhaps let me rephrase that, an authority which was not binding or of assistance on this claim, which is addressed within the which is addressed within the authority of Mr. Justice Briggs, as was in Magical Markings Limited, which was identified yesterday. In that respect, my lord, maybe I can turn you to that. You'll find it at page 40 of the supplementary appeal bundle. Now, I accept immediately that this is a High Court decision, and obviously it's not binding on this court, but nonetheless it is a decision of one of your now brother judges, and in my submission it does carry weight. But more importantly, what it did was it resolved tensions between, or seeming tensions between authority, the line of authority which started with Roach, which was quoted in Islam and Ali, which is set out within the defendant's skeleton, and the notion that where there is minimal damages recovered in the broader context of a claim, the starting point is that that ought to be viewed as a success for the defendant, and particularly in commercial claims. However, there were two authorities, Fox and Foundation Piling and Medway and Marcus, which dealt with personal injury claims, and in particular the question of exaggeration within personal injury claims, such that there appeared to be a tension between those two lines of authorities. And what Mr. Justice Briggs does in my submission is that he resolves that tension. You can see this as a starting point from paragraph 5, and it's engaged with the question of who is the successful party. The reference, of course, are under the old pre-2012 references to the CPR, but nonetheless it's exactly the same rule. And what one has as the factual matrix of magical markers is set out at paragraph 2, and it's a stark position. The claimant had recovered £28,000 against a claim for 10 million.
Yeah.
So the question there was, how does one deal with the costs in that circumstance? And the position in terms of the law was put forward at paragraph 5, that there was nonetheless acknowledged that a more nuanced approach to the process of identifying the successful party has emerged from a series of Court of Appeal authorities, and then Roach and newspaper group newspapers is quoted. And what it identifies that the court must do, it is stand back and look at the particular factors of the case and ascertain as a matter of substance and reality who has won. That dictum was then applied in a further series of cases. You'll see that at paragraph 7, and in particular Painting in Oxford is cited, which was a decision of this court from 2005 at neutral citation CIV 161. Again, a further personal injury claim, so different to this claim which is before you, where there was £25,000 judgment against the £400,000 claim, where their Court of Appeal concluded there that the defendant was nonetheless the real winner, since the proceedings had been mainly concerned with the disproof of what turned out to be exaggeration. We then see Islam and Ali, which of course is the authority which is before you, and cited in the skeleton not only below but on this appeal. And what that concerned was a claim for accountancy services which was put at broadly £156,000, and the recovery made was just over £12,000. Again, what the Court of Appeal concluded in that instance was that the defendant was the successful party, and the decision of Lord Justice Auld was quoted from paragraph 23, and it's replicated here. And it says this: the disparity between what Mr Islam sought, including what he put Mrs Ali through to get it, and what he received was so large as to put the relatively small amount finally awarded in the balance between the two rival contentions into insignificance.
Yes.
And then the resolution of the tension as to how one follows or the tension is drawn out thereafter at paragraph 10, which is the difficulty caused by the dissenting judgment of Lord Justice Jackson in Medway. It is an authority that was drawn to our attention yesterday in respect of that tension. The split decision was that Lord Justice Jackson in Medway concluded that because there had not been a Part 36 offer, one had to view the successful party through whether the claimant had recovered anything at all, as opposed to contextualising and taking that nuanced approach as to who was the winner when one looks at the amount which had been sought and the amount which had ultimately been obtained.
Well, it's a bit odd that in his judgment in Fox, which was handed down about a week later, he doesn't refer to Medway at all.
No, no, absolutely. It is a curiosity. And perhaps a further curiosity is that he doesn't, in Fox, go down the Roach approach either. There are a number of curiosities from those judgments, my lord, absolutely. But perhaps in terms of principle, what one sees from them...
It may be that because, as Mr Justice Briggs points out, it was really about the Part 36 regime.
Absolutely, and that's not applicable here. Though I think it is fair to say that the comments from Lord Justice Jackson were such that there ought to have been a Part 36, and that was a factor which weighed in his balance in Fox. But of course, that is addressed within magic markers at paragraph 14 as to whether there ought to be a situation where a penalty, in effect, ought to be visited upon a successful party for, in effect, not making that level of offer. And the difficulty, of course, in that position, in my submission, my lords, is this, is that when one makes a Part 36 offer, one has to have account of the cost consequences which flow from it. And when one is dealing with a de minimis claim, as this is, in the event that the claimant makes a Part 36 offer for a minimal amount of damages, the cost consequences that will automatically flow under the Part 36 regime is that the claimant would be entitled to recover all of their costs through that process. Whereas if one looks through the authority line, starting with Roach, going through Islam and Ali, what one sees is that situation, that factual situation, ought to be treated as de minimis recovery. So in those circumstances, the defendant would be entitled to their costs. So what one sees is that there is potentially a tension between using the Part 36 regime and the authorities on where the successful party would automatically fall in circumstances where there is a de minimis recovery. So in my submission, that explains why there ought not to be a penalty applied for the failure to use the Part 36 regime in these factual, narrow circumstances. And that is as reflected within the judgment of Mr Justice Briggs, as was set out from paragraph 14. And in particular, one sees the authority of Osgaloo from 1998, where the judgment of Lord Justice Brooks said this: in this line of cases where the plaintiff only recovers between 1% and 3% of his original claim, the court is entitled to ask itself who was essentially the winning party, and it ought not to be distracted from making a just order as to costs in the absence of a payment into court, analogous now to the Part 36 regime. And I say that that's important to this claim, because if one looks through the lens of the rewards claim, the claimant has recovered 1.5%. So what one sees is that that directly falls into the de minimis, insignificant recovery category, which ought to immediately direct to the defendant being the successful party. If one then goes back to the judgment of the judge in this case, particularly to paragraph 23, sorry, forgive me, 25, we'll see that the judge considered that it was important that the claim advanced by the claimant was considered by him not to be unreasonable, because it concluded in his view that it was never appropriate to award the defendant the costs of the rewards claim, and that the most that he ought to consider doing is depriving the claimant of the costs of that claim. And in my submission, what that does is that's an impermissible misdirect as to identification of the successful party. The manner in which a claimant puts a claim, whether it's reasonable or not, is immaterial when it's a de minimis recovery claim to the level in particular of 1.5%. This is to be distinguished from the line of authority through Fox and Foundation Piling and Medway and Marcus, where there has been exaggeration from a claimant in a personal injury claim. And the factors in particular as to whether the conduct was unreasonable or not is a displacement factor, rather than going to the proper identification of a successful party.
It's maybe nitpicking, but if one looks at paragraph 25 closely, the judge says it could never be appropriate to award the defendant its costs, which suggests he's looking at the corporate defendant,
Yes.
against whom the rewards claim was not levelled, as opposed to the personal defendant against whom it was.
It's a point that I'd missed, my lord, but yes, one can see that absolutely. It may be that the criticism or the response that will come back from my learned friend is that this was an extempore judgment,
Yeah.
and it was given within that context. But nonetheless, one can see there equally that irrespective of whether it is nitpicking or not, that is the language that was utilised. And in any event, the principle, irrespective of the ultimate target, is that the judge took into account wrongly whether it was reasonable to bring the claim or not in the identification of the successful party. And in my submission, that is not an appropriate factor on the Roach principles.
In paragraph 31, referring to the defendant, he does say he rather than it, so one can see the different approach. But in fact, the skeleton arguments don't appear to highlight that the position of the second defendant needs to be treated separately from that of the first defendant.
The skeleton arguments underneath, my lord.
Yes, yes. I mean, it seems to be a point which doesn't appear to be taken, at least in writing. So although the order the judge made has what you say is the unfortunate consequence for the second defendant, I'm not sure that was spelled out to the judge, and it seems a bit hard to criticise him if it wasn't a point that was taken.
Well, the analysis, of course, is still on the defendant's position that the rewards claim failed. So it still has to be, in my submission, analysed through the lens of the rewards claim, and the second defendant was never part of the rewards claim. So consequent to that, when one is identifying the successful party, as Ms Carter, in my submission, properly did, she could only ever have been engaged and concerned with the first defendant in any event. And in my submission, that the framing of it through that lens is such that that the parties were a relevant factor to that, rather than specifically setting out that there ought not to be a cost order against the second defendant, particularly when she's identifying it through the lens of a claim to which the second defendant was never a party. So whilst I can understand the court's concern that it's not directly spelled out, in any event, the thrust and the direction and the context of Ms Carter's skeleton argument was still as that aligned with this appeal. But even if I'm wrong on that, my lord, the position, of course, on this appeal is that in the event that there has been a serious procedural error of law, irrespective of whether it is a point taken underneath or not, the protection, of course, to any party aggrieved is whether they've been prejudiced by the taking of the point now, And in my submission, that can't be correct on analysis of the facts of this appeal due to the event of the Respondents' notice, which has been properly dealing with this point on the claimant's case to say, well, it ought to be a third-party costs order if the judge was wrong on the first starting point. But even if I'm wrong on that, then of course the correct approach that I would invite your lordships to take is to take this into account when one is dealing with the question of the costs of the appeal, as opposed to the principle in the event that your lordships do in fact find that there has been an error of principle or law or on the principle judgment that the judge gave.
I mean, in essence, I think what you say is that although it's recognised in countless appeals that judges have a very wide discretion over costs, the identification of the successful party is not a question of discretion.
No.
It's a pre-existing exercise which the judge must go through before the judge gets to the exercise of discretion. And if you go straight to discretion without identifying the successful party, then the exercise of your discretion is vitiated.
Absolutely, because one starts in the wrong place. My lord, absolutely, you've put it far more eloquently than I have, and that's absolutely the defendant's case. And one can see through the judgment that what the judge did was he took it as a matter of discretion, but equally what that led to was a misdirection on the principal point as to who was the successful party for the reasons that have been given. And when one treats the rewards claim and the identification of the rewards claim in terms of the successful party, in my submission, there can never be any proper sensible acceptance that there has been a success on the rewards claim for this claimant. They recovered de minimis damages amounting to 1.5% on the rewards, the gold payment itself, but quite more pertinently, my lords, and I would suggest that more weight ought to be given to this point as well, which is the way in which the gold payment materialised. You can see this helpfully set out within the judgment, the substantive judgment on damages at page 38 of your bundle from paragraph 77.
Well, your client's expert, having gone through the records, found that at step E of the scheme, when Build-Tech was supposed to reimburse Mr. Heathcote, they over-reimbursed him to the extent of £7,800. And I don't think, correct me if this is wrong, that the claimant's expert ever found that, or indeed went into that level of detail in looking at the EBT scheme. He attacked it in principle.
Absolutely. You're absolutely right, my lord. Yes, exactly so. And the consequence of that is that if one looks at it practically and principally, the defendant's almost been hoisted by his own petard by having that level of diligence and discovering this payment, which then the claimant seized on as their factor to say that they succeeded in the rewards claim. Equally, that claim or the identification and the extent of the issue, in my submission, was insignificant in the balance of the matters which were brought as part of the rewards claim. And one can see not only that in terms of the level of damages recovered, but as to the effect that this isolated issue had in the balance of the rewards claim itself. It was identified by Mr. Tasuka. It was dealt with immediately. Questions were put to the first defendant. It was immediately accepted that that was an overpayment, and the money was paid across, and it was done within the space of 11 weeks.
I don't at the moment, subject to what Mr. Weiss may say, find it difficult to accept that if one looks at the claims separately, then the claimants won the payment claim and you won the reward claim. But it seems to me that the question is whether the judge, who must have been well aware of that, is entitled to look at the case globally or is required for cost purposes to treat them separately. And you've given the Superwall case as, I don't know if you say as an example of when they have to be treated separately or whether that is the rule in all circumstances. That is only if there is economic connectivity or whatever it is that you said. I mean, it's possible to imagine all sorts of claims, for example, on a final accounting between parties who've been in a relationship where there are a host of separate claims which might have to be looked at, which don't really have anything to do with each other apart from the fact they're all part of the account, and party wins on some and loses on others. Why shouldn't the judge, in some circumstances, take a global approach to seeing who is the overall winner?
Because further on this, my lord, it is over and above the position on the Superwall claim, is that the language in my submission, insofar as 44.2.2a is concerned, is that it ought to be viewed through the lens of the claim itself, because of the language that is utilised in terms of the reference to party to, and in my submission, what that lends itself to is an understanding of party to a claim, because in particular the language itself, if one turns to 44.2a itself and then one looks through the displacement factors at 44.2.4, what one sees is that they're all as an analysis through success or otherwise between connectivity between the parties. So, for example,
well, I think the point in Superwall is there are different parties to the claims.
yes,
If it's one against one, then of course the judge can take an overview of who won what. But if it's one against two and one against one joined in a single action, then the position is different.
well, it will if one looks at it through that lens, one will have to obviously ascertain the base. That there are circumstances where the parties, there is such connectivity between them that there is joint claims that are being brought, or that there are joint defences that are advanced. But when one looks through this claim for the reasons given, this is not a joint defence, nor was it a joint case brought against the first and second defendant, nor was there any connectivity between the payments claim nor the rewards claim. So in my submission, even on the facts of this case, there is no avenue through which one can sensibly say there was that level of connectivity. And whether one looks through the Superwall case, or again, whether one looks through the more broader all the circumstances, which is directed again by the displacement factors at CPR 44.2.4 and onwards, one sees that there needs to be an element of connectivity between the party that shares the burden of being the burden of being the paying party, the losing party who ends up having to pay costs, and the successful party who recovers their costs. So taking for way of an example, CPR 44.2.4a requires the court to consider in terms of conduct whether the extent to which parties have engaged with the pre-action protocol.
Yeah.
Well, again, the pre-action protocol can only engage between parties where there is that level of connectivity. Equally, if there's been success on issues or not, and the extent to success on issues, again, that can only come into play in the event that there is connectivity between parties through the lens of a claim which is being brought. So in my submission, even if one looks at the language and the intention of Parliament in the rules themselves, what one sees is that there has to be this level of connectivity between a party who is asked to pay a costs order or considered to be paying a costs order and the party who is going to get the benefit of that costs order. And in my submission, it makes little sense if one is looking through the displacement factors and through which the court has to exercise its discretion to try and analyse those through parties who have no connectivity between themselves. So even on a language, on an interpretative process through the language of CPR 44.2, what one sees in my submission is that there has to be that level of connectivity. And that, in my submission, is the thrust of where one is going at Superwall at paragraph 64 and at paragraph 65. And the exception at paragraph 65, my lord, to answer the question that you put to me, is that there still has to be that level of connectivity. Now, financial burden may be an example of connectivity, but there still has to be the principle, in my submission, of that connectivity itself. And what one doesn't see in this case, on the factual basis, particularly because of the difference between the benefits of the first defendant and the recovery potential for, or the financial difference between the first defendant and the second defendant, given that the first defendant was a personal, an individual, and the second defendant being the company in voluntary liquidation, such that it's vested in the liquidator, is that there is no connectivity between.
So is it critical then that the second defendant is in liquidation, so that the interests of creditors and so forth may come into play, whereas previously the first defendant was the sole director and he and his wife were indirectly the sole shareholders. And if that position had continued, would the order be subject to the same criticisms that you're making? Because there would be that, what you call, connectivity between them.
In those factual circumstances, one could see that there could be a potential for such an argument, but that's not the fact of this case. Not least, of course, because there had been an assignment between the liquidator and the claimant, such that the benefits from any monies recovered in the liquidator are actually going to flow to this claimant themselves. My Lords, that in my submission goes through the position in respect of the principle. And as your Lordship has rightly stated, the principle and the identification of the successful party is a question of law and a question of principle. The discretion thereafter operating upon that question of principle as directed through the balance of Part 42 it is not, in my submission, a question directed by the issue directly of who is the successful party, because those displacement factors can only go to offsetting the position of a successful party once one arrives there. And for the reasons given, the successful party in this case, sensibly in the rewards claim, is the first defendant. My Lord, there were various authorities which were put before this court, including Plevin and Paragon, which went to the crux of or were going to be the position that was going to be argued in respect of the identification of the narrow confines of a claim, which have been broadly overtaken by the Superwall case. Unless you'd like me to take you through Plevin and Paragon to assist, it seems to me that Superwall takes us no further. So I don't think Plevin takes us any further than where we are in Superwall, my Lord. So that's an explanation for why I don't think you need to be taken through that case. As to the identification of the successful party, the position in respect of that, I've taken you through in particular, I've taken you through the Fox and Foundation and Marcus, magical markings in particular. I can take you through Islam and Ali very quickly, my Lords. It ought not to take a moment. That's at page 39 of your authority bundle. I've skipped through this briefly already. This was the accounting claim pleaded at 156 and recovered at £12,746. And the principal paragraphs that I drew your attention to are at paragraphs 23, which you'll find at page 43. This is the quotation which was cited in particular in magical marking. But the paragraph which was not cited was the one below, which is at paragraph 24, again underlining the principle of law in respect of identifying the successful party. In my view, the judge erred in principle in failing to have due regard in the exercise of discretion to the fact that Miss Ali had won the case in principle, or as near could be, is given the large completing sums being canvassed. Again, this is further support for the strict line of authority in de minimis recovery cases where the identification of the successful party is to a defendant who has enjoyed magnitudinal success in a claim, even where the damages recovered are minimal, because one stands back and ascertains the reality of the situation.
Yeah.
There's also Marathon Assets, my Lord, which you'll find at page 45 of your authorities bundle. paragraph 3 in particular, which cites Hyde Park Residence Limited and Yelland, which engages with the notion of the recovery of nominal damages, and the lengthy trite position, I would go so far as to say that the recovery of nominal damages is considered in reality a loss.
But nominal damages is £2, not 7,800.
Well, £2, of course, in a claim that's a smaller amount can still amount to potentially a small percentage. But of course, and that's what I say this claim is a 1.5%.
Well, I follow that, but it's not nominal damages.
I'll move on from that point then, my lord, thank you. So having ascertained the position as to the successful, or that it's ought to have been analysed through the reference of the claim, my lord, where does that take us? In my submission, where I would invite you to next, is having a look at the rewards claim itself as to understanding where the exercise of discretion ought to have operated. Cantering through those matters quite quickly, I'm quite aware that I touched on a number of them already. The successful party, of course, in my submission for the reasons given, that ought to be the first defendant. Thereafter, one turns to the displacement factors under CPR 44.4, and one looks at the relevant factors there. We land firstly on the issue of conduct, which brings us neatly to the issue of mediation. On that mediation, my lord, if I can turn you to the case of Halsey and Milton Keynes, which you'll find at page 70 of your appeal bundle, authorities bundle.
Well, the judge dealt with mediation, didn't he? He said it wasn't unreasonable to refuse to mediate.
Not quite, my lord, in
No?
fairness. He said it was not unreasonable to mediate until December.
Oh, right.
Thereafter, he found that it was unreasonable to mediate.
So let me just have a look and see what he says about that.
But his approach to mediation is on the premise of his view about successful party. So if you're right about successful party, then perhaps we don't need to be concerned with what the judge said. If you're wrong about successful party, do you go on to say that the judge, even so, was wrong in what he said about mediation?
Absolutely, because what one sees what the judge did in terms of where he placed the burden of mediation, he placed it on the burden of mediation of showing that it was unreasonable. He placed it squarely upon the first defendant, or the defendants, in fact. But when one analyses it through in the event that you're with me on the analysis of the claim, what one sees is that there are two burdens in principle that must be satisfied under the Halsey principles. Firstly, the burden's on the unsuccessful party to show that the successful party acted unreasonably in refusing the mediation.
Sorry, where are you now?
Forgive me, my lord, I'm at paragraph 13 of Halsey.
Of Halsey.
Yes, my lord, which is at page 73, I think that is.
Halsey has suffered a certain amount of collateral damage recently, hasn't it?
It has, but the principles and the foundations still remain in my submission.
And it's paragraph
13.
Yeah.
So in the event that you're with me, my lords, that the first defendant was the successful party, we see how the burden operates to show that the mediation was unreasonable. And the burden is on the unsuccessful party. So in this instance, on this hypothetical factual situation, one sees that the burden would be on the claimant. The burden would not be on the first defendant to show that its decision to not to mediate was unreasonable. The burden is on the claimant to show that. And then as a facet of the above, my lords, perhaps just skipping forward ever so slightly before I come back, is to go to paragraph 28. And this engages with the burden of showing that the mediation had no reasonable prospect of success. And again, the burden is not to be on the refusing party, but the offering party. And that what they need to show is that the mediation, in terms, had a prospect of success. And then going back to paragraph 16 to ascertain what the features are which would direct towards that burden or not, one sees at paragraph 16 that the nature of the dispute itself is relevant. I don't say here, my lords, at all that this was a case which was, the nature of the dispute was necessarily not suitable for mediation. But what I do say is that on the merits of the case, this case was difficult in my submission to have dealt with under mediation for the following factual reasons. The defendant had repeatedly set out that it had a very strong case. And what one sees is the paragraph here of being particular appropriate weight, because what is said there is if the position was otherwise, there would be considerable scope for a claimant to use the threat of cost sanctions to extract a settlement from a defendant, even where the claim is without merit, and courts ought to be particularly astute to this danger. And then one goes over the page to paragraph 19, the second substantive paragraph down. In our judgment, this statement should be qualified. The fact that a party unreasonably believes that his case is watertight is no justification for mediating, but the fact that a party reasonably believes that it has a watertight case may well be sufficient justification for refusal to mediate. So what that does in my submission is it brings in an element of subjectivity upon the successful party, that in the event the successful party considered they had a strong position and there were no reasonable prospects of success, that there is an ability to properly refuse that mediation offer. Here, of course, it's entirely relevant in terms of the factual matrix, in terms of tactics, that this is a claimant is a litigation funder, and its business is to make profit from litigation. So there is a driver in my submission from the claimant side to get this settled as soon as possible and cheaply as possible, because it goes towards its business model.
But I mean, if we're talking about mediation, it may be thought to be unrealistic to maintain the distinction between the two separate claims. If there had been a mediation,
Well, there was
everything would have gone into the pot, wouldn't it?
It practically and sensibly speaking, wouldn't sit there and say we're having a reward payment claim mediation one day and a payments claim mediation the next day. Absolutely, but that doesn't go to the identification of the successful
No, I follow
party.
that, but you've gone past that.
Yes.
And you've gone on to what you've called displacement factor.
Yes, absolutely, and it becomes a question irrespective of whether it's offered against one party or two parties or six parties, however many parties there may be in a case.
So let me just get this straight. If you're right about the successful party on the rewards claim, then you say there's no reason to hold mediation against the claimant, against the defendant, Mr. Heathcote, on that claim, because looking at that claim separately, he reasonably thought he had a watertight case. There's no reason why mediation should play any part in the costs order on the payment claim, because the two defendants are going to pay the costs anyway. If you're wrong about Mr. Heathcote being the successful party on the rewards claim, then
We don't get to mediation.
then the judge's order can stand. Can't it?
Well, that can be
Subject to the company being excluded from having to pay the
Absolutely.
those costs.
Which is why I'm analysing it through where one ought to have fallen in respect of the rewards claim itself, because that thought process, my lord, is absolutely apposite as to where one ends up when one filters it through the matrix, and the position gets the outcome gets kicked out at the bottom of that as a process. Absolutely, but if you're against me on the first defendant being the successful party, one doesn't really get to mediation, which is a curiosity again of this judge's decision making, because he did take that into account as a factor, whereas if he'd have having concluded that the claimant was the successful party, the reality was that there wasn't any need to go anywhere near the mediation. And again, in my submission, all that does is it shows impermissible logical thought process of the judge when one looks through how he arrived at the costs order. But may I take you now to the actual positions adopted by both parties, which you'll find on the mediation point, which you'll find in the supplemental bundle, forgive my back, at page 217. This is the final offer which was made for mediation. You'll see it comes in January 2022 on the 17th. Now, the judge had concluded that it was reasonable to refuse mediation up to December. The next point in time, and the only point in time when mediation was offered again, was on the 17th of January. So in my submission, the judge's determination that the mediation refusal was unreasonable in the event that we get there must be considered in the context of this correspondence on the 17th of January, and also the context of the claim as at the 17th of January. You'll see that the offer there is, or the letter itself is short. Our client is willing to meet 50% of the mediator's fees and the venue fees. That is of relevance, my lords, and I draw that to your attention. There are no reasonable grounds for your client to refuse. What I would invite you to find from that letter, my lord, is this, that it seems to have the hallmarks of a standard letter. There is no engagement with the specific facts or circumstances of this case as at that date. And I say that that's relevant, and it's relevant for the wider context in which that mediation offer was put. The case management conference had just been had in December. The directions given. So at the point the offer was made, no further evidence had been exchanged between the parties between the point of December and January. So there had not been, in my submission, any particular evidence exchanged between the parties to show where there ought to be a movement from the position from December. So on that basis, if the position in December was reasonable, it's difficult and curious to see how, when nothing has changed to January, the decision in January was also unreasonable. But if I can take you back 2 pages, please, to page 215.
Sorry, can I just go back and understand how these factors affect the judge's ultimate order? Have I got it right that what his process is that, first of all, he's going to look at it globally, and take the 2 claims together, which you say is wrong, and on that basis the claimants are the winner. He then looks at reducing their costs below 100%, and he arrives at 50% to take account of the fact that the claim on the rewards claim didn't succeed. And he then has Mr. Cochrane's 3 points, paragraph 29, which poses the question, should I make a deduction of 50%? And he then has the 3 points, part 36, called bank offer and mediation, which together bump it up to 75% rather than 50%. Is that the process?
I don't think, I'm not, I think it was a bit more nuanced than that, my lord. The 50% deduction, as I understood it, was to reflect success on the rewards claim. Yes, rather than to reflect the mediation.
Yeah, absolutely. That's what I meant to say.
Oh, sorry, my fault for misunderstanding.
And it's then the mediation and the part 36, which reduces the discount by taking it up to 75.
Yes, absolutely. Well, one can see that there is a factor. We're not ever told what the percentage is that's applied, but he puts it all in the pot.
Oh, okay, sorry, I interrupted you, but that's helpful for me anyway.
So if we look at the position as at the 25th of October, what one sees in particular is 2 factors. The 3rd paragraph down engages with the financial situation of the first defendant in particular. and this is given through the lens of that first defendant, that the failure of the business has had a significant effect on his health and financial position, so that he would be unable to meet a claim of the size against him. This is in addition to the fact that since the events in question, he's been through a personal divorce and has seen 3 companies in liquidation. He also references the current company is in arrears with VAT and PAYE. The current company, as I understand it, is a separate company outside the confines of this claim, which was still running and hadn't been put into voluntary liquidation. So what that does is it sets out the position of the claim, the first defendant's finances. The conclusion is that as a consequence of that, the first defendant can't pay for mediation at the same time as running the claim through litigation. And there's a request for the CMC to be vacated in the event that mediation is to be undertaken. So what one sees actually, in my submission, is that the claimant is, there's no direct refusal to mediate in principle. It's a timing issue. It's a timing issue and it's a monetary issue. What the first defendant is saying is I don't have the money to run parallel processes through which to deal with this claim. I can deal with them sequentially, financially, but I can't deal with them in parallel. Claimant, if you allow the CMC to be vacated and to be stayed in effect, then I can deal financially, sequentially, we can deal with the mediation, then we can continue on in the event that one gets that far. And you'll see your wholly unnecessary approach of insisting the CMC remain in place regardless of the fixing of a mediation forces our client to select one or the other approach. So when one is considering whether there is an unreasonable refusal to mediate or not, it has to be seen in the context of what the claimant also decided. And the decision was, we want to press on, we don't want to have a mediation and a pause. And in my submission, that speaks volumes, and it's illuminating, and it's illuminating for this reason. Had the claimant been, the true intention being that this claim, they wanted to mediate this claim and to settle this claim through mediation, it's inexplicable why they would not also have a focus on that rather than a focus on the CMC and the litigation track continuing. In my submission, that is a fatal difficulty for this claimant, because they bear the burden of proof to show why the refusal to mediate was unreasonable, and the context of that is their own conduct in refusing to vacate the CMC and to continue down the line of the litigation itself. I say that that is critical. The second point to be taken from this letter of the 25th of October is the first defendant's perception and their subjective...
I'm sorry, Ms Bedford, but
yes.
What the judge said about mediation doesn't seem to me at the moment to be one of the grounds of appeal.
I accept that, but my lord, this is the situation in the event that you're with me on the first ground of appeal, which
so
is
if we exercise our discretion afresh.
Exactly, absolutely. Yes. I accept that on the alternative, if you're against me on the alternative grounds, I'm solely in the realms of discretion.
Yeah.
And equally, I also accept that that is a high bar that I need to leap in any event. There are the second and third grounds, so the third and fourth grounds of appeal, which do engage with the discretion. I'm addressing the exercise of the discretion afresh within that primary context. So one can set off in the event that you're against me on the first principle.
In view of the time estimate, we need to pick up the pace
Yes,
a bit.
sorry. Well, so what one will see here is that the perception of the first defendant was that the mediation in any event had little prospect of success because of the principle, because of the position adopted. The response to, so that was the position from the first defendant as at the 25th of October. Nothing had changed, simply that the parties had moved through the CMC to the 17th of January. What one also sees on the 17th of January from page 218 to the 17th is, again, in the context of the claimant's conduct, their position was to make a Part 36 of 585 in totality. And then we get to the defendant's response, which was on the 27th of January at page 221. where there is a recitation of the previous difficulties and also that there is a further delineation that the mediation would have little prospect of success because of the fixed mindset. The burden here again is on the claimant in the event that you're with me, and against that context in my submission, that burden can't be properly moved in the context of the factual matrix as was present within January 2022.
Yeah.
And we then get swiftly to the offer. First of all, for the reasons that I've given previously, that the difficulty with this £85,000 offer is that it was made in respect of both claims.
Where are you now?
This is 44.4c admissible offers,
Yeah,
my lord.
page.
This
You're
is,
looking at some correspondence.
no, my lord,
Right.
forgive me, that's my, I think it was, well, the beeping was going on, sorry. Going back to the discretionary factors and the displacement factors, there is an offer that was made. The court will need to take that into account to some degree. The difficulty with putting any weight on it at all is that it doesn't set out who, or forgive me, it doesn't specifically say in relation to the rewards claim, we will offer you this amount of money. So when one is looking through the lens of the reward claim against an offer that was made, there simply wasn't one that can use as a comparative to ascertain whether there's been more money recovered on it or not. The terms, of course, were made within 21 days of trial, so we come back to the point of the costs offer or the cost consequences that I previously set out. That was for the claimant to receive all of their costs, and on the analysis of the correct legal position, that was never going to be, in my submission, a comparable offer that the defendant would lose against at trial. Equally, to show that at this point the reality was all about costs, the defendant had also made their own £85,000 but all-inclusive offer, which was rejected on the 26th of August 2022. You'll find that as simply as a notation, my lord, at page 304 of the bundle. So in the event that the court feels that it is able, or considers, forgive me, it is able to put any weight on this aspect, in my submission it ought to be minimal in any event. There are various consequences that the court can do. The court can, of course, award the first defendant its costs all the way up to the expiry of that offer, and no order as to costs on the trial. The court can award a percentage reduction, and in my submission, the offer itself, given the terms and the lateness of it, this is only in the event the court finds that the offer, of course, has been beaten. That the lateness of it, in my submission, ought to be a very minimal reduction, somewhere in the order of around 5 to 10%, if anything. My lords, can I quickly canter through the respondent's notice?
Yeah.
The respondent's notice, for the reason given, only kicks in my submission, or only manifests itself in the event that you are not with me, forgive me, on the first defendant being the successful party. Because otherwise what one will see is that there would be a successful party defendant, but nonetheless the claimant seems to seek a costs order in its own favour against an external party. In my submission, that is manifestly illogical. So this can only affect if the claimant is the successful party. But in any event, the difficulties to this position in relying on Threlfall are twofold. Is that there are jurisdictional difficulties because the test on making a third-party cost order is simply not made out on the factual analysis of this claim. You'll find, my lord, Threlfall at page 53 of your bundle.
Yeah, you have to show, or the claimants would have to show, that the upholstery company was the real party to the rewards claim.
Yes.
And as far as I understand it, the rewards were paid to Mr. Heathcote, and he kept the benefit of the rewards.
Absolutely. So on a very primary basis, there is simply no factual satisfaction of the test in any event. So in my submission, the respondent's notice is misconceived. My Lord, unless there is anything further that I can help you with.
Thank you very much.
Very grateful, thank you.
Yes, Mr. Vice.
My Lord, I'll deal with the question of whether the judge was entitled to look at the case globally or was required for cost purposes to treat the two cases separately. That's the first point. Now, my Lord, in this regard, I address you on Flitcraft. In my submission, Flitcraft is not an answer in favour of my learned friend in the way she expresses matters. It's merely an example on the facts of that case, of a scenario in which it was not appropriate to look at the two claims together for the purposes of determining who was the winner overall. It is not an authority that therefore says in another case, on different facts, you may not look at the claims together. The point is noted that at paragraph 74 of Flitcraft, there were separate causes of action vested in separate claimants. And the point is noted that that would have resulted in separate judgments. But as my learned friend acknowledges, at paragraph 65 of Flitcraft, Lord Justice Nugie's judgment left open the possibility that in certain cases it would be appropriate to look at success for one side of parties overall, if I can put it that way. By reference to the particular facts of Price and Superwall, the way it was put in paragraph 65 is that depending on the circumstances, it may make sense to regard substantive success by any claimant as success for the claimant interest overall. An example is given of the associated parties. Now, what my learned friend says in argument before yourselves is that for it to be appropriate to treat the claims together, there would have to be some kind of connection between the parties. And she said that financial burden could be a connector. Now, looking factually at this case, you can see from paragraph 8 of the main judgment which is at page 28 of the core bundle.
Yes.
That Mr. Heathcote was the sole director of the company prior to its insolvency. He and his wife were at the relevant times the directors and shareholders of the holding company, which was the sole shareholder of the company. He and his former wife were directors of contract of the second defendant, of which the holding company was a sole shareholder. And he goes on to say his wife took no active part in the affairs of the companies. Now, the second defendant was not, as I understand it, in liquidation, nor was the holding company in liquidation. So there is a commonality of interest there between the two defendants. Mr. Heathcote and his wife are the ultimate beneficial owners of the second defendant through their share ownership of holdings. So in my submission, there is a connection in this case between the defendants that could justify the two claims being treated as one. And what is another ingredient that justifies the two claims being treated as one for the purposes of analysing the question of success? Well, that is the manner in which the parties address the court below. Because in my submission, when one looks fairly at the skeleton arguments, one can see that the defendants were very much not saying, Judge, you need to treat the rewards claim and the payment claim as different claims. Judge, the first and second defendants recognise they should pay costs on the payment claim, but the claimant should pay costs to the first defendant on the second, on the rewards claim. That was not the argument. The argument was that success should be looked at overall by conflating, for the purposes of analysing success, the two claims. Now, in my submission, one can see that that was clearly the argument by looking at the skeleton argument. I'll take you to it simply because there's some additional paragraphs I wish to refer you to. You've seen already that the claimant sought an order that the defendants do pay the claimant's costs on the standard basis. So the claimants, my learned friend rightly says, were conflating the two claims. At no stage can one see the defendant say that is a wrong approach. To the contrary, what the defendants say, this is at page 215 of the core bundle. Paragraph 11 is that they invite the court to order that the claimant pay all of the defendant's costs of the claim on the standard basis. That is the defendant's primary position. And it's clear from that the defendants were proceeding, as I've indicated, not inviting the court to distinguish between the two claims, but to treat them as one. And that point is made good by paragraphs 16 to 18 at page 216, a point that His Lordship has already picked up on, that it is said that notwithstanding the claimant's success on the payment claim, the defendant should be treated as the overall winner. I mean, that is the thrust of paragraph 18. And in my submission, that is to conflate the two claims for the purposes of determining who is the winner. Now, an alternative criticism is that, or an alternative way of putting the same criticism is that the judge then impermissibly treated the two separate claims as issues within the proceedings. But that's exactly what the defendants do. And I say that by looking at further paragraphs of the skeleton argument. So we can see here at paragraph 23, there is the court is being addressed on the alternative position. If the court isn't with the defendants on their primary position, that they should get all their costs of both claims, despite the fact that the second defendant lost on the payment claim, the defendants invite the court to make a proportionate, in particular a percentage costs order, and they go on to set out options in order of preference. And one can see at paragraph 26, the point is made that the claimant has only recovered 11.12% of the value of its entire claim, meaning that defendants have been successful in defending 88.88% of the claim. And that is used to support the submission that, as an alternative, the court should order that the claimant pay 88.88% of the defendant's costs. Now, that in my submission is clearly to invite the court to treat the rewards claims and the payment claim as issues within the proceedings. So is the way the case is put at paragraph 27 onwards of the skeleton, where you can see at 27A, the point is made that the court might feel that the rewards claim dominated 80% of the overall claim, and therefore make a reduction of 20% to reflect the claimant's recovery on the payment claim. B, the court is addressed on no order as to costs, and it said that that should not be an appropriate order. More pertinently, at C, go a step further and make a percentage cost order that reflects the level of success achieved by value, and order D's to pay 11.12% of claimant's costs and C to pay 88.88% of defendant's costs.
So your point here is that the options that were presented to the judge did not include separate orders on each claim.
Yes.
And although, had the point been taken, it might have been a good one, the fact is it wasn't, and the judge can't therefore be criticised for exercising his discretion in a way he was never asked to exercise it.
Well, yes, and go a step.
In fact, it goes a little further if you look at 29, doesn't it? Because D's do not believe that an issue-based cost order is practical or appropriate.
Well, precisely. I mean, that's the paragraph I was going to take you to in due course, my lord. So you have the point, and what I say is that Superwall, therefore, recognising it does that there may be circumstances where it's appropriate to treat claims together for the purposes of analysing the question of who is the winner, isn't against me, because here, in this case, the defendants were saying, don't treat them separately, treat them as one. We're the winners overall. And there is a commonality of interest between the defendants, given that the first defendant is the ultimate beneficial owner of the second defendant. And so, how can the judge be wrong in proceeding as he did? Is my submission. Now, it also makes perfect sense that the defendants would have proceeded this way below. And this is why, in my submission, it ill behoves them to now raise it on appeal. Because they had, of course, lost the payment claim, but they weren't saying below, we accept we have to pay those costs. That wasn't their position. They were saying we should get all the costs of the claim in its entirety. And given the situation they were in, it's unsurprising, therefore, that they chose to conflate the two claims. Because by so doing, they could say to the judge, all right, well, we did lose on the payment claim, but overall, by value, the recovery was still small. It was 11.12%, is the point that they were making. But they can't now complain then when the judge took the view that 11.12% wasn't so small a recovery, and it meant that they weren't the losers overall. And in my submission, that's really what they're doing now. Now, as against that background, therefore, as I've said already, I say the judge proceeded correctly in the manner that he looked at the question of who was the winner. And that obviously takes me to paragraph 29 of the costs judgment. Paragraph 21, forgive me, of the costs judgment. And in paragraph 21, the judge posed a correct question to himself, who has won? And he took the view that the claimant had won on the payment claim, that the claimant had succeeded in part on the rewards claim. You can see that in the penultimate sentence. And he took the view that overall they were the winners. So he looked at the question through the correct lens because he took as his starting point the question of who is the winner, and he was entitled to look at the two claims together for the reasons that I have said. That obviously takes me on to a related question, which is, was the judge wrong to consider the claimant the winners given the level of recovery made? And did he deal incorrectly with the absence of Part 36 offers made by the defendant?
Right, when you say the level of recovery made, you're still treating both claims together?
I am, yes.
I don't think it's been argued that...
Yes, well, very well. What we say is that clearly, if the two claims can be treated together, it was within his discretion to form the view that the claimant...
No, I think Miss Bedford's point is that your starting point is to separate the two claims.
Yes.
And when you separate the two claims, then the recovery on the rewards claim and the circumstances in which it was recovered lead you to the conclusion that the first defendant succeeded on the rewards claim.
Yes, my lord. And I've addressed your why I say the judge was entitled to look at the two claims together.
Yes, yes.
But it does seem to me, though, that part of the argument that's being raised is that the learned judge took an incorrect turn in the way he looked at the question of Part 36 offers and whether or not they had been made. I've formed the view that's the argument being run because of the references to Fox and to it being said that he followed Fox. And obviously the two cases that you invited us to consider yesterday suggest that perhaps Roach would be in a more appropriate way of looking at things. Now, what I say is that the judge, if the mischief is this, that Fox shouldn't be taken as meaning claimant makes a recovery, but small, D makes no offer, therefore claimant wins. So Fox shouldn't be taken as meaning that. The judge didn't fall into that error because he didn't interpret the case that way. And we can see very clearly that paragraph 21 is where he addresses the question of who is the winner. And it's no part of his consideration, and defendants made inadequate offers or no offers, and therefore claimant is the winner. He does look at the question of the offers, but he does so as part of what my learned friend calls adjustments or displacement factors, the second stage of the exercise. And of course he's perfectly entitled to do that. It's part of all the circumstances of the case as stipulated in the rules. So, in summary on that point, what I say is that the judge didn't err on that first question of looking at who is the winner. He didn't impermissibly form the view that simply because inadequate offers had been made and the claimant had made a recovery, the claimant was the winner. That is very much not the exercise at paragraph 21. The exercise is the question of who is the winner. If one looks at it through the prism of Roach, stepping back and look at the substance and reality of the case and asking oneself who is the winner, well, that is what the judge was doing at paragraph 21.
Yeah.
Now, in terms of whether the judge then erred in the way in which he applied the exercise of adjustment factors, in my submission, it can't be said that he did. One can see at paragraphs 23 to 25 the points noted by the judge about the absence of exaggeration, the absence of unreasonable conduct on the part of the claimant in taking the rewards claim to trial. Now, as I understand my learned friend's submission, what she says there is that the judge was turning a winning party, the defendant, into a losing party by the manner he looked at these factors. But in my submission, he's doing no such thing on a fair reading of the judgment, because the judge has already determined at paragraph 21 who is the winner. He's now looking at the question of whether he should make some sort of different order. And what he is saying, he's already found that the claimant is entitled to its cost to the successful party, prima facie, but he's looking at, is there a reason for making a different order? And what he's saying is, if there had been exaggeration or unreasonable conduct, maybe that would be a reason for making a different order. That is surely what is being said at 23 to 25. But I haven't found that that's the case. And so I'm not going to rely upon those factors in order to make a different order. Now that in my submission is a completely proper treatment of those factors. He's not saying they're a reason for making the claimant a winner. He's therefore not impermissibly elevating them.
Now, he's having identified the claimant as the winner. He's now going on to say, well, from the starting point that the claimant gets its costs, should I make some deduction from those costs? And I don't make a deduction because it's unreasonable.
Yes.
25 is I don't make a deduction because it lost some issues.
Yes.
I don't make an issue-based order.
Yes.
So that's the second of Mr. Justice Arnold's, or third actually, of Mr. Justice Arnold's questions. Is it appropriate not merely to deprive the winning party of its cost, but also to require it to pay the same
Yes.
cost? So that's the question he's addressing at 25.
Yes. Yes, and so he's not, the point that's made by my learned friend is he's impermissibly elevating these factors into a reason for finding the claimant to be the winner.
No, he's already
not.
found.
Yes,
He's
precisely.
already found the claimant.
Precisely. That is my point, my lord. That is my point. Now, we can see at paragraph 27 to 26 to 28, he looks at the question of whether to make a percentage reduction, and he deals with the defendant's submission that since the payment claim was only 11% of the full value, then the cost reduction ought to be 89%, and he forms the view that actually it's he can't say anything more than it would be an equal time and effort. Now, that in my submission is something that's quintessentially the province of the trial judge. Those aren't my words, that's the way it's put at paragraph 76 of Flitcraft, and when the same point is made. Now, the defendants may say, well, we don't agree, we think the rewards claim took up more time, but it's a difference of 30% between what they say, 80%, and what the judge maintained, 50%. And can't be said to be perverse and outside his discretion to have formed the view as the trial judge that it was 50-50. So he then...
Well, their approach is value-based rather than time-based.
It is. But so in my submission, that is something that is within his discretion. He then looks at the question at paragraphs 29 to 31 of, if I form the view that on a 50% of the time was spent on the rewards claim and they haven't substantively succeeded with say for the payment claim, should I make a 50% reduction to the claimant's costs? Now that in my submission is an unimpeachable step in logic, and the factors that are then taken into account in considering what percentage reduction to make are proper factors. I mean, the first point that's made there at paragraph 29 then is the absence of any relevant Part 36 or admissible Calder Bank offer by the defendant. Now, that's the right place in which to consider the question of the offers. As I've already said, it is not to elevate them into reasons for making the claimants a winner. And on the facts of this case, the judge was perfectly entitled to take into account the absence of any defendant's Part 36 offers as a factor, amongst others, that he would take into account when considering whether to make any adjustments. It's not a case where, on the extreme facts of, say, for example, Medway, it could be said that the defendant was perfectly justified in not making a Part 36 offer. I mean, you know the facts of Medway. I mean, the point is that with the ATE premiums and the CFA fees and the like, the costs were huge. But that isn't the case here. You may have picked up on the fact that the claimant's cost budget was agreed at £91,000, I believe. That's stated in the one of the skeleton arguments below. So this isn't a case where the costs ran away with themselves. For this type of litigation, they were relatively modest. And the judge obviously is looking at a scenario where the defendants have lost on the payment claim, and they have had to pay monies in respect of the rewards claim for which he has entered judgment. Now, the judge will be perfectly entitled to think to themselves, well, it might have been sensible to make a Part 36 offer that reflected the claims that they've lost on. And you know, if one looks with this at the benefit of hindsight, one can see that it's in May that Mr. Teshub, and I hope I'm pronouncing the gentleman's name correctly, raises the question of the 7,800, and no offer is made at that stage by way of Part 36 to compromise the payment claim. No offer is made to compromise the rewards claim by way of Part 36. And at that stage, there would have been significant cost savings. And out of a budget of £90,000, we're at the first stage of the expert reports. We obviously avoid the costs of the PTR and the costs of the trial. Claimant's costs might have been less than £50,000, given they'd been agreed in total at £90,000. We haven't had a mediation either, which was budgeted for. So for the judge to say, well, it might have been, in terms, it might have been sensible for the defendants to make a Part 36, and I'm going to take that into account, in my submission is an unimpeachable conclusion on his part. Now, it said that the judge placed excessive weight on the claimant's own Part 36 offer, but in my submission that can't be right. Excessive weight would be if he'd said, well, the claimant's made a Part 36 and you didn't accept it, and so claimants are the winners. But that just wasn't the reasoning. I mean, the reasoning is...
well, excessive weight is not usually a ground on which an appeal court interferes with discretion. Leave out of account is one thing, but excessive weight, that's a matter for the decision maker.
Yeah, he noted that it was a late Part 36 offer. As a matter of fact, the claimants had judgment in their favour for more than the amount that was offered. He took the view that the defendants could have got out of the trial if they'd accepted that offer. And he thought that was a factor that meant that instead of making a 50% reduction, he would make a 25% reduction. That is not in my submission outside the ambit of his discretion, and something in my respectful submission that the appeal court should interfere with. Now, as to the refusal by the defendant to mediate, I mean, again, this was a matter within the discretion of the judge. You've been addressed in some detail on that in case you exercise your discretion afresh. And so I will also therefore make some detailed submissions on the point in case you do exercise your discretion afresh. But in my submission, it was quite right to form the view that after the CMC in December, there was thereafter no reasonable justification for not engaging in mediation. I mean, perhaps the first point to make is obviously part of the reason that was put forward by the defendants, as noted by the judge at paragraph 35, was that the defendant's solicitor in his witness statement said that defendants did not have the means to mediate as well as fight the case. But one needs to stand back and look at the reality of this, though. As I said earlier, the claimant's budget was agreed at £91,000. The defendant's budget was, I believe, £83,000 or thereabouts. The defendant had budgeted in total £10,000 for ADR. I think we need to turn that to that, but that's in the core bundle at page 239. And that included counsel's attendance at the mediation, which one might consider to be a luxury. So at their very highest, the defendant's costs of the mediation were £10,000, and he might have taken the view, I'll forgo counsel's attendance, and the cost would have been substantially less. It's difficult to understand in those circumstances how a lack of means could justify the decision not to partake in mediation.
Well, the judge deals with that at paragraph 35.
Yes, quite.
He doesn't accept it.
I agree. I say that's the correct conclusion to reach, and I say that if you exercise your discretion afresh, you should also form the view that a lack of means wasn't a good justification for the failure to mediate. Now, it's also said that the refusal to mediate was justified because the parties were very far apart in their offers, and because the defendant remained open to less formal and thus less costly routes of ADR. Now, just dealing with those points by reference to some of the correspondence in the supplemental bundle, page 210 in the supplemental bundle, my lords. So this is an invitation to mediate on the 11th of October 2021 by the claimant solicitors. And the significance of this is that, as you can see in the first 6 paragraphs or so, the parties have engaged in exchanges of information in correspondence. And so the point is made, well, now we've done this, and you've put forward what you say is your version of events, defendants, let's have the mediation. Now, there is a further email at page 212, again dealing with mediation. There's a further exchange of information because in the previous correspondence at page 211, the defendant solicitors had said it's disappointing that you haven't provided information, so now some information is provided. And it said at the bottom of the page that the claimant's solicitor their client believes they have a very strong claim, but they're willing to mediate at an early stage in order to avoid further costs being incurred. At page 213, the availability of the mediator is sent by the claimants to the defendants. There's a chaser at page 214, and then at page 215 there's the letter you've already been taken, or the email you've already been taken to, where the defendant explains his position and says, and this is the point that's relied upon at the bottom, last paragraph, and the penultimate sentence, the final sentence of the penultimate paragraph, whilst he's always been willing to engage to try and resolve this matter, formal mediation with its inherent costs is simply not going to be appropriate. He's perfectly willing to continue to engage with you through ourselves to deal with any specific matters to narrow the issues. And this is relied upon to say that the defendants remained open to less formal and thus less costly routes of ADR. But in my submission, what is then missing after that is any invitation by the defendant to less formal or less costly routes of ADR. It's not like he's saying, and I invited them to a roundtable meeting on a without prejudice basis, or I suggested an early neutral evaluation or the like. There's none of that. So in my submission, one could probably form the view that whilst it says here I'm willing to engage to try and resolve the matter, but I'm not interested in a formal mediation, that is in my submission to pay lip service to the requirement to engage in ADR. Because actually the defendants can't go on and then say, and we invited them to do X, Y, and Z. And in my submission, that's underscored by a further item of correspondence at page 221, the supplemental bundle. I mean, the context is that there's been a Part 36 offer from the claimants to settle the entire proceedings in the sum of £585,000 on the 17th of January. That's at page 218. And then at page 221, what the defendant, through his solicitor, says on the 27th of January is, second paragraph of the email, your Part 36 proposal isn't helpful as it merely reiterates how far apart the parties are. What possible purpose is there in a mediation where your client has its fixed mindset and unrealistic expectations? And you can see what he says. He goes on to say, we're proceeding in accordance with the court timetable. So, in my submission, that does demonstrate that the earlier reference to an ongoing interest in other forms of ADR was lip service only. The defendants clearly formed the view, the other side are making very high offers. I don't agree, there's no point. And the judge, in my submission, was perfectly entitled, therefore, to conclude that, as he did at paragraph 34, that disparity between offers can't of itself justify refusal to mediate. Just because they're very far apart doesn't mean that one can't have a settlement. And the second point he makes is that when the defendant, the claimants make the Part 36 offer, the late offer, which of course is one of £85,000, when push came to shove, the claimant was willing to accept a significant discount. So he goes on to say it can't be said that because the claimant was saying we're confident we'll win, that the mediation had no reasonable prospects of success or that the refusal to mediate was justified. In my submission, that's a perfectly correct conclusion, and if you come to exercise your discretion afresh, I say you should reach the same conclusion. Now, just dealing with the question of the second defendant specifically, because obviously, you know, one of the issues here is, as the other side say, the effect of the judge's order is that the second defendant is, in terms, liable for an element of costs that may be referable to the rewards claim, to which it wasn't a party. Now, in my submission, there was sufficient jurisdiction and discretion open to the judge to make an order with that effect. Given Price and Superwall explains there are circumstances in which claims may be taken together, and given that is what the parties were asking the court, the judge to do, to take the claims together. Because the defendants clearly were saying, we are the overall winners, and we want all our costs, even though the second defendant has lost. I mean, the corollary of that...
You say that it was open to the judge to do that. Was it ever pointed out to him that that was, in fact, the effect of what he was...
I cannot see that it was. I did not appear below. I cannot see that it was. No.
Nothing we've been shown?
Nothing that I have seen. No. Nothing you've been shown and nothing that I have seen. The point I'm making, though, is that in terms, the defendants, they can't have it both ways. They can't say, look at it overall, treat us as the winners overall, because even though we lost on the payment claim, we should be looked at the winners overall, and then complain when the judge says, well, I've looked at it overall, and actually I think you're the losers overall.
Yeah,
it's
well,
just
that goes back to your first point, doesn't it? That
it does.
The judge can't be criticised for exercising his discretion in a way he was never asked to exercise.
No, it's a case of buyer's regret on the part of the defendant, in my submission. But if I need more support for the judge having taken this approach, that's when I draw the analogy with the non-party costs order.
That's a difficult one for you.
Well, I mean, I understand why you say that, my lord. I understand that. But I mean, if we just look briefly at Threlfall, and I appreciate all the factors that are set out in Threlfall.
Well, Threlfall was a case in which Mr. whatever his name is, can't remember his name, was the controller of the company.
I understand that point, and that is, I mean, that factual difference between this case and Threlfall is completely right. I mean, I completely accept that. But the point I was just going to make by reference to paragraph 11 of Threlfall, if I can just briefly take you there. That's at page 53 of the bundle. I mean, the point is made at paragraph 11. This is now page 55 within the bundle, the authority having started at page 53. The courts have repeatedly repeatedly against, I mean, there's a word missing there obviously, but the courts are against overburdening cases of this kind with reference to decided cases, and I will attempt to heed that warning. The ultimate question is whether it's just to make what is an exceptional order. Now, I appreciate that there's then a very detailed, paragraph 13, identification of relevant factors to this case of Threlfall that made it appropriate to make an exceptional order, and none of which apply in this case. I see that. But there are factors in this case in my submission, not factors that applied in Threlfall, that can be prayed in aid of an exceptional order. And those factors are, and there is a circularity here to my submissions, but it's the approach the parties took on costs, including the defendants, which was not to invite the judge to distinguish between the costs of the first and second defendant, but to treat them as one, and not to distinguish between the costs of the rewards claim and the costs of the payment claim.
How does that differ from your previous submission that the judge can't be criticised for exercising his discretion in a way he was never asked?
Well, it's the same point, but I'm simply saying here through the prism of the exceptional order that Threlfall says is a non-party cost order, such an order could be justified.
But you're not saying that if the judge had been asked to consider the two claims separately, he could still have made the second defendant pay part of the cost of the rewards.
No, I'm saying having been asked to treat the two claims together.
So if just let me get this straight, if we were to accept Miss Bedford's submission that the judge made an error of principle in running the two claims together, do you say that even if he had, as she would say correctly, treated the two claims as distinct, he could still have ordered the company, the second defendant, to pay 75% of the costs of the rewards claim to which it was not a party?
No. I don't say
And I don't think this goes further than your main submission, does it? Which is that he can't be criticised for not.
No, I mean,
done what he
the
was
point,
never asked to do.
the reason I raise it in the respondent's notice is because the judge didn't expressly say, and there is the situation here could be deemed to be analogous with a non-party cost order. And my point is that I say it could be because those are exceptional orders in which the consequence of the order is that a party who isn't in a claim is nonetheless fixed with a liability for it. And that could be, in my submission, an alternative way in which he could have framed his reasoning, but his reasoning would still have depended on the factual matrix of the case before him, which included, in this case, the parties are asking me to treat the costs as one and not distinguishing between their costs. That's my position, my lord.
Yeah. Right.
Now, if you're not with me and you look to exercise your discretion afresh, I'll press you on that. Now, in that scenario, it seems to me that you've reached a conclusion that the judge should have looked at success through the confines of the individual claim. And so I'm batting against a situation in which my client's recovery in the rewards claim is obviously at the very low end. In those circumstances, I say that it's still a case where the claimant should receive its cost of the rewards claim from the first defendant, but appropriate adjustments may be made for the circumstances in which what I say is a victory arose. Now, why do I say one can properly treat this as a win? Well, this wasn't an aside in my submission. It wasn't a situation where the 7,800 was an afterthought, unlike the general damages in Medway, which, as I understand it, were for not providing painkillers when the underlying claim was about something much more substantial and much more valuable. As you have seen, the way the first defendant's liability for the £7,800 came to be recognised was squarely because of the expert's analysis of key issues in the case.
Well, your attack in the particulars of claim did not say, assuming that the EBT scheme was remuneration, nevertheless, Mr. Heathcote has been over-reimbursed. Nor I think did your expert ever say that.
No, what we said was in terms, well, the case was one about the misapplication of trust property.
Yes, quite. It was, what your case was that this EBT scheme was improper for one of a number of different reasons.
Yes.
You didn't say, well, even if it was proper, it's been overused, so to speak, in that Mr. Heathcote's been reimbursed more than he should have been.
Well, the underlying claim placed in issue £520,000 that the director had received,
Oh, quite.
and said there is no lawful basis for that 520,000.
Yeah.
And it transpires that of that 520,000, there was no lawful basis for
Yes,
the
well, it
7,800.
was within the pleaded claim in the sense that it was less than the 525,000,
Yes.
and you got it.
Yes, yes. And you know, we all know we're talking about settled principles here, as the judge expressed below. You know, the parties agree that the onus is on the defendant as a director to justify having had payments from the company, and he can't justify 7,800 of the £520,000 in issue. But that's the kind of pleading point. What I'm trying to explain also is that it wasn't like it was a mere aside, oh, by the way, we owe 7,800 that this came about. It was because of the experts having to analyse specific issues in the case that were relevant to the pleaded claim. So if I can just explain what I mean by reference to some of the underlying documents briefly. So the list of issues for the experts is in the core bundle at page 223. And one can
I see at 222 there was actually an order that parties must consider ADR.
Yes, my lord, yes. And it's in that context that Mr. Rubin, the solicitor for the defendants, produced a witness statement which the judge refers to in his judgment.
Yep.
One can see at paragraph 7a at page 223 how were payments by Cervico Buildtech to the first defendant recorded in Roman numeral 1 the accounts of Cervico Buildtech Limited, and at page 224 C, did the tax planning create an overdrawn director's loan account to the first defendant? Because it was being argued that the payments out should be treated as a director's loan account. So it's in the context of looking at those issues that Mr. Teshuba comes to address the 7,800. One could see that that's what he's doing just by looking briefly at his first report. That's in the supplemental bundle at page 77. So one can see the issue set out at the top of page 77 under 3.1, how were payments by the company to Mr. Heathcote recorded in the accounts of the company. And then at page 79, Mr. Teshuba's analysis of the accounting records entries, the bottom of page 79 by the second hole punch. And he notes the remuneration expense in gold of £270,000, Cervico's liability to pay for the gold of £270,000. And over leaf at page 80, he notes that Mr. Heathcote assumed responsibility for Cervico's debt to Asset Hound, that's the gold dealer, £270,000, a debit of £270,000 to one of the director's loan accounts, cancels the liability. Mr. Heathcote is given the benefit of this by a corresponding credit of £270,000 to a director's account. And then there is a difference of £4,050 between the accrual for the liability and the invoice referred to in the Asset Hound email of 27th November 14. I've not been able to explain this from the papers. I can see that the situation is complicated by deposits and fees paid. And he makes a similar point then over the next 2 pages in respect of the second reward.
Yeah.
And so it's in that context that it arises. And as the point's already been made to you then, at this stage he says he can't explain it. It's dealt with in the joint report in that it's referred to therein. Mr. Kitson, the claimant's expert, in his second report, gives this discrepancy between the £270,000 and the 4,050 and 3,740 as an example of how he says he questions whether the cubic tax avoidance scheme was implemented at all. One can see that at page 107 of the supplemental bundle. So one can see at page 107, paragraph 1 in summary of conclusions, the principal difference between the experts is whether or not the cubic tax avoidance scheme has been implemented in full, part or at all. And at paragraphs 14 and 15, one of the reasons that Mr. Kitson relies upon is the issue of these credits.
Sorry, 100 and?
107,
107, my lord. Oh, paragraph 14, yeah.
yeah. So that's part of the reason that Mr. Kitson gives in his second report for doubting whether the tax avoidance scheme has been implemented in full, in part, or at all. And as the point has already been made to you, answers are put to Mr. Teshuba, questions rather are put to Mr. Schuber to explain whether there was an entitlement to retain the 4,050, the 3,750. I mean, interestingly, he has two goes at answering it. In the first go, he says he can't answer the question, and in the second go, he does. The first go is at page 131 to 132. Question 8 at the bottom of page 131. You can see, my lords, the contents of Mr. Schuber's report is summarised to him, and then he's asked at page 132, is there any evidence that Mr. Heathcote became entitled to additional credits in the sum of 4,050 and 3,750? He goes on to say there's uncertainty, he's unable to express an opinion.
Yeah.
And then
he comes back to it at page 139 and he says it's due by.
Yeah, so what it is, my lord, is at page 136 is that he has another go at answering the question. It's actually revised, it's a further answer, a revised answer, dated the 22nd of August 2022. And at page 139, he then provides the answer and he says very clearly, Mr. Heathcote owes 7,800 to Cervico. That's at page 139, paragraph 2.7. The point I'm making, though, is this. As you can see, and as I submit, I've demonstrated, the gold payments, they're not an aside. They are part of the expert's consideration of whether there was a lawful basis. Well, legality is obviously ultimately for the court, but what was the basis for Mr. Heathcote retaining the 520,000? And as part of that analysis, the claimant's expert concluded that there was no justification for retaining 7,800. So it's not an aside, it's very different from Medway. It is a small recovery, but it can't be said that no rational person would have issued a claim for £7,800. People do all the time.
Spending £100,000 on it.
Well, that was including the cost of the payment claim, of course. So in my submission, it's not one of those cases where one can say it's a very small sum and the costs are ridiculous. They've run away from themselves. It's obviously a defeat. It's a modest recovery. It's a modest recovery. Costs weren't ridiculous. They hadn't run away with themselves. And it was properly a part of the case. So in those circumstances, I say that having recovered the sum of 7,800 on the rewards claim, if you exercise your discretion afresh, the claimant should be seen as the winner as regards the first defendant. But of course, it's open to you to look at all the circumstances of the case and make adjustments as you deem fit.
Yeah.
Now, in that regard, certainly on a time spent basis, the judge took the view that it was 50-50 between the rewards claim and the payment claim, and that's quintessentially a matter within his own domain. So,
yeah, I mean, the problem with that is that the judge was never asked to adjudicate on the 7,800. So when he says 50-50 between the rewards claim and the payments claim, that's in the context of the remaining 515,000.
Yes, but perhaps I can put it this way, though. In order to establish this entitlement to the 7,800, the claimants had to issue the rewards claim and generate the costs of the rewards claim. And it was only paid on the 5th of September 2022, so only just before the trial. So, you know, I can see how one might say, well, we didn't need to debate the rewards claim in hindsight, we didn't need to debate the rewards claim at trial. You should have just accepted that it was your 7,800 and then we would have just had a trial on the payment claim. But that's actually a very small amount of costs. The costs of the trial referable to the rewards claim. A very small amount of costs. And that's why I say that if you make a reduction to the claimant's entitlement to costs, you can properly say that, say, 75% of the costs of the rewards claim ought to be recovered by the claimant. To reflect the fact that he had a trial and the issues at trial the rewards claim he didn't succeed on, but he didn't actually get his 7,800 until just a few days before the trial, and so he reasonably ran it up until that point. So those are my submissions as to an alternate order. There obviously being no dispute that the first and second defendants should pay the claimant's cost of the payment claim. Yeah. Thank you, my lord.
Yes, Ms. Bedford.
Thank you, my lord. Yes, there are 4 points very quickly on the cost point, and I understand Ms Carter has a singular point in respect of the burden of the actual or granular issue on the claim, if I may. The first point is this issue-based cost order from a premise that my learned friend says amounted to the defendant's position on the skeleton. When one looks at it, that was actually the alternative position that was advanced by Ms Carter. And one can see that very clearly delineated out in the skeleton argument that the issues-based cost order was asked as an alternative position rather than the primary position. So in my submission, all of the criticisms that flow from that can't properly be levelled at the judge's failure to address the primary position, that it needed to be analysed through the context of the claims and the success on that. The second point that arises out of that, of course, is that the issues-based approach is part of the factors considered on the displacement in the event that a party succeeded on an issue or not. That again, my lord, goes to the point that you made earlier, that it's a discretionary factor rather than the principal factors to identifying the successful party. If I can just address as my second overarching point the issue of mediation, the position there in respect of the mediation and the criticism that no further ADR was offered, it's correct that there was no request for a roundtable meeting of that nature, but there was a request that the claimant sent over any counsel's advice to show the strengths of their claim to persuade the defendant on their position, and you'll find that at page 232 of the bundle. I would suggest that that is a form of trying to narrow the issues in an alternate way, and if that's what alternative dispute resolution is to be viewed at in its overarching sense, if one is looking at informal ways of approaching it, in my submission, making that request is not something which is to be dismissed. It may be that you apply little weight to it because it's at the bottom of the spectrum, but nonetheless I do say that it is a qualifying factor, and I would invite your lordships to take account of that. Thirdly, this notion that the court, the judge below, equated the equal time and effort at 50-50, and in my submission that doesn't help the claimant for this reason. If both claims were to be treated equally in terms of the value, so in terms of the time and effort, in my submission that goes to each party bearing their own costs on the claim, as opposed to the claimant receiving 50% of their costs overall in respect of both claims. In my submission that simply doesn't follow, nor does it follow that the costs burnt ought to be a relevant factor in identifying the successful party. The relevant factors are the valuations of the claim, not the cost burnt in getting there. And in any event, one sees that the claimant received £7,800 out of the 520, which leaves £512,200 that they did not receive, and the vast majority of the costs in my submission went to that unsuccessful.
Well, that's difficult for you to make in this court because the judge has decided equal time and effort.
But that goes to my primary position, that if that's the conclusion, which it was, that goes to each party bearing their own costs, if nothing else. But of course, if they'd have been seeking the £7,800 as a standalone claim, the reality is that that probably would have been allocated to the small claims track with the lack of cost-bearing jurisdiction that entails. And I say in my submission that weight ought to be given to that as a factor. And then finally, the Medway point. The facts and circumstances in how the Medway payment came out aren't, in my submission, as quite as stark as what my learned friend puts them to be. The issue of the failure to provide adequate analgesia prior to the leg amputation actually came out at cross-examination on trial in Medway, and consequently is that they'd launched that as a basis upon which to claim the very limited PSLA payment. So again, it was a very minimal feature, similar in my submission to the way that this the £7,800 gold claim came out. And if that had been identified by the liquidator, of course, within the liquidation, as it properly ought to have been, it wouldn't have featured at all to the extent that it did within this claim. My lords, unless there's anything helpful I can give on the cost position, my learned friend Ms Carter's got one more point to make. Thank you, grateful.
Yes, Ms Carter.
Afternoon, my lords. My lords, I just want to very briefly address this connectivity issue that's been raised by both sides by reference to paragraphs 64 and 65 of Flipcraft. I have to acknowledge that my learned friend Mr Weiss was correct in drawing to the court's attention that the second defendant, of course, was not insolvent. At the point in time, they weren't in CVL. Any references to insolvency, of course, was to the company itself, i.e. Heathcote Limited. So what we have to do is ask ourselves, is there any economic connectivity between the first defendant and the second defendant? But of course that question isn't asked in a vacuum. It's not simply a case of, is the first defendant a director of the second defendant? And there's your answer. You've got to look at this question through the lens of looking at this claim. And when we ask that question looking at this claim, what we see is that there wasn't any, or there was arguably very little economic connectivity between the first defendant and the second defendant. Now, the rewards claim, of course, related to the first defendant only, because the rewards were paid to the first defendant only. But more importantly, any economic benefit flowing from the rewards went to the first defendant only. There was no recycling of those funds, so to speak, back into, for example, the second defendant, or indeed any other connected company within the Heathcote group of companies. It was simply a benefit paid to the first defendant for him and potentially for his wife, who was previously a director but not involved. Now, just to highlight where there could be connectivity, and it doesn't go to the first and second defendants, it goes to the fact that there was connectivity between the first defendant and the company itself, because of course the rewards...
Which company?
Upholstery. Heathcote Limited, so the company in liquidation. Yeah. And this is just an example of how we could get this level of connectivity that, in my submission, the judges are considering in Flipcraft. And that is to say that between the first defendant and Heathcote Limited, there was more of a connection here financially when we look at the rewards, because what this ultimately was a tax avoidance scheme, if we take a step back. And the benefit was always going to be the non-payment of tax. Now that benefit fell on both the first defendant and the company that then went into liquidation. Because of course tax consequences could follow personally through D1's own tax returns, but also there could have been tax consequences on the company itself. And this was something that was discussed during the trial and the judge acknowledged. And it was a strange situation in which HMRC were going after, if I can put it that way, after both the first defendant and the company itself for tax in relation to these rewards. And the practical effect was actually that it wasn't the case that if one of them paid, the other one didn't have to. There were separate tax liabilities, and ultimately, if HMRC had proceeded against both the company company and the first defendant, they could have received tax from both of them. And therefore there's this economic connectivity between them. And I only raise this not because it goes directly to the point, but because it highlights that there was no such connectivity economically between the first defendant and the second defendant. It simply wasn't the case. If the claimant had been successful against the first defendant on the rewards claim, it would have been the first defendant who had suffered, so to speak, and had to pay that £520,000. It wouldn't have had any financial or economic effect on the trading of the second defendant. So I think it's really important to draw that distinction and to say, or in my submission to say, there wasn't this level of economic connectivity which the court was discussing in paragraph 65 of Flitcraft, because first and second defendants had their own separate interests in their defences. It wasn't a case of one had an effect on the other.
Yeah.
That simply wasn't the practical effect. And I would also note as well that even if the court isn't with me on that point, when one looks at paragraph 65 of Flitcraft, what is clear from the language is that even where there is a connectivity, that isn't determinative of the starting point. The judge made clear in that case that it's only a may, depending on the circumstances, where the court might consider it correct to take a step back and treat the success or the failure of one party as the success or the failure of the other party. But what that doesn't do is change the starting point. And this brings me full circle back to my own friend's main thrust here, and that is the starting point is to identify the successful parties in relation to each of the distinct claims, and then in some circumstances the court may take a step back and then decide to treat the success or the failure of one as the success or the failure of the other. But what that doesn't do is change the starting point of identifying the successful party in relation to each of the distinct claims, because it's very clear that even in Flitcraft, when we're looking at paragraph 65, that was the starting point, and that was the point being made by the judge.
Yeah.
So that's all I wanted to say in relation to connectivity, unless I can be of assistance any further.
Thank you very much.
I'm grateful.
Well, thank you both, all three of you, for your arguments. We will reserve judgment. You will get a draft in the usual way. That will be your opportunity to correct our English but not our reasoning. The draft will come with an embargo, which means what it says. We would hope that in the light of the draft judgment you will be able to agree in order disposing of the appeal. But if you can't agree in order, please make short written submissions. We will make the order we think appropriate, and any future hand down of the judgment will be electronic and remote, so there's no need for any further attendance. Thank you all very much.